attending the webinar. It's one of these webinars that we hate to give, but unfortunately some Supreme Courts surprise us with decisions that sort of make our jobs a little more difficult. As we go through the webinar, we are going to have a trivia question at some point during the webinar. I'll give you a question and you can provide your answer in the question pane on your dashboard. And then the first one to answer the answer question correctly will win a book of your choice. We'll reveal the winner at the end of the webinar. Jamie will email the winner after the webinar to find out which book you want, but we will announce it so you'll know. At the end of the webinar, well, I'm going to actually skip this part. I was going to let you guys know, most of you know that our website is a resource for subrogation professionals with lots of charts on statutes, limitations, MedPay, PIP subrogation, contributory negligence, comparative fault, deductible reimbursement, which, by the way, we had to edit that chart yesterday as a result of this decision, made whole doctrine, automobile total loss thresholds, et cetera, et cetera. We have a map that you can click on and get the law in any state. And these are things that will help you in your subrogation practice. A couple of the points we have to go through for those of you who are obtaining CE credit. After the webinar, a survey will pop up. We're going to ask that you answer a couple of questions that we feel, so that we have a good feel for how you think we're doing on the webinar. And the Texas Department of Insurance requires us to prove that you were in attendance. For those who are getting Texas CE credit randomly during the webinar, Jamie, who's in the background monitoring the webinar, will send out a message to everybody, which will show up in your question pane, which I referred to earlier. So it's going to ask if you want Texas CE credit. If you want it, type yes and click send. The message won't expire. When you see it, answer it. If you don't need Texas CE credit, just ignore the message. And that way, Jamie has a record for the TDI that you were present. So we're recording this webinar. The webinar will be available on our website in case anybody missed it. So welcome to the webinar on Washington's Subrogation Shakeup. A new Supreme Court decision turns subrogation on its ear. I am going to be co-presenting today with one of my favorite local counsel, Eric Vershbo. Eric joined the law firm of McMillan, Schultz, and Marks in 2001. He's a shareholder there beginning in 2009. His practice focuses on civil litigation with an emphasis on subrogation. He is in Oregon, but he handles, and he's licensed in Washington, handles Washington subrogation, and I lean on him frequently when we have situations like this, which arise in Washington. So Eric, welcome.
Hey, thanks, Gary. Really appreciate it. Glad to be here.
All right, I will start off. I'm going to let you know that we have, I think this may be a record, I'd have to go back and check, 891 attendees. This includes conference rooms, and again, we don't know how many people are in the conference rooms, so it's a minimum number, but that's a tremendous turnout for, and I think it's testament to the confusion that has been created in Washington. Before I start, I just want to say this is 9/11, and it's important an important day for all Americans. 18 years ago today, 19 men hijacked 4 fuel-loaded U.S. commercial airplanes bound for the West Coast. A total of 2,977 people, including 343 New York City firefighters, 23 New York City police officers, and 37 Port Authority officers were killed in New York City, Washington, and outside of Shanksville, Pennsylvania. So I just wanted to mention that our thoughts and prayers go out to the victims and their families. We will never forget. I know they will never forget. So with that preface, let's begin. The reason we're here today is because of these 2 Supreme Court decisions that have a big impact on subrogation in all lines of insurance in the state of Washington. I think we all know as subro professionals the disaster which can befall a anti-subrogation state like Montana when it decides to side with trial lawyers and turns its back on small businesses. By extending the equitable doctrine of the made whole doctrine to all lines of insurance and declaring that an insured must be made whole and totally reimbursed for any losses, any such state takes an absurd position that an insured must be totally reimbursed for all losses before any subrogation rights accrue. They do so at the peril of the small businesses in their state. The state of subrogation in Washington is now in a state of chaos thanks to these two decisions. I will mention the Washington Supreme Court, and this is a little way of background. It's interesting and important for us to know the battle, the civil war that is going on within the subrogation world. The Washington Supreme Court, who decided both of these decisions, has 9 justices. They're only one of 5 states that has 9 justices. The rest have 7. All 9 justices are Democrats. I will not make a partisan pitch or appeal here, because the reason I mention this is that because that fact means that that Supreme Court is going to side with trial lawyers almost all the time. If there were 9 Republicans on the Washington Supreme Court, it wouldn't necessarily mean that we were safe. And this is what's insidious about the state of subrogation in America. It reveals and betrays a lack of subrogation education among all lines. A lack of subrogation education for the legislators who make the laws, a lack of subrogation education for the justices in our courts of appeals and Supreme Courts, all the way up to the U.S. Supreme Court. If you remember the Knudsen case back in 2002, which rattled health insurance subrogation to its core, the majority who wrote that decision, which was anti-subrogation, were Republicans. And they tend to believe, well, we just don't want any more lawsuits. There's too many lawsuits, and these pesky subrogation suits just serve no purpose. Well, that shows ignorance in both parties with regard to the valuable right of subrogation that we all know and enjoy. It's how we make our living. But again, this is just an appeal that if you have an opportunity to educate, do so, because these cases are an example of a lack of education. I think it was the Spanish philosopher George Santayana who once said that chaos is the name we give order, which produces confusion in our minds. So with that definition in mind, these 2 decisions are responsible for about as much chaos as you can possibly throw into one state's body of subrogation law. So it would stand to reason then that if we can eliminate the confusion, we can also eliminate the chaos. And that's what we're going to do. Now, I'm going to go through in summary fashion what happened in these 2 decisions. Then I'm going to talk a little bit of, we're going to do a little bit of a background or a sort of a recap on Washington subrogation, so you'll have some idea of how the law in the past has been affected by these 2 decisions. And then at the end, Eric is going to provide you with some recommendations and best practices. So I know that's what you're going to be waiting for, is how does this affect how I handle Washington subrogation? We will get to that. But first, we have to understand what happened. So on May 7th, 2019, the Washington Supreme Court decided the case of Daniels versus State Farm Mutual Auto Insurance Company. This decision reversed the Court of Appeals decision. Your PowerPoint may say affirmed. That was a mistake. It reversed the Court of Appeals decision, and this case directly and significantly affects both deductibles, deductible reimbursement, and represents a major expansion of the made whole doctrine in Washington. So here's the facts. Daniels, who was insured by State Farm, had a $500 deductible. He was in a 3-car accident. He was the middle vehicle in a rear ender. The driver in back was insured by Geico. The driver in front by Liberty Mutual. State Farm paid for Daniels' repairs. His insurance company paid for the repairs and then did the prudent thing. They recovered 70% of the subrogation because they felt, from Geico, because they felt that was Geico's responsibility, and reimbursed Daniels 70% of his deductible. Fair enough. Well, apparently not for the trial lawyers. And believe me, the trial lawyers, and we do have some trial lawyers in attendance. They like to tune in because they want to learn about subrogation because it's a major component of representing their clients. And I don't blame them. That's their job. But the trial lawyers, and I'm a member of the AAJ and formerly ADLA, I know that there's listservs out there, and this concept of filing class actions because some subrogation rule wasn't followed to the T is becoming commonplace, and that's what happened here. A trial lawyer filed a class action suit against State Farm for breach of contract, bad faith, conversion, and they claimed that under the policy and under Washington law, State Farm could only subrogate after Daniels was made whole. This means they needed to reimburse the full deductible to Daniels. State Farm filed a motion to dismiss. They relied on the case of Averill versus Farmers Insurance Exchange, which Eric will talk about later. That's a case which said that the made-whole doctrine does not extend to this type of subrogation action. And they also relied on a Washington Administrative Code, which requires the subrogated carrier to return deductibles less applicable comparative fault. So the State Farm policy in this case had the following clause, the following term in it. It said, our right to recover our payments applies only after the insured has been fully compensated for the bodily injury, property damage, or loss. Not all our policies have that clause in it. They don't build the made-whole doctrine into their policies, but this one did. And that makes this another poster child for the adage, bad facts make bad law. Well, if that was a bad fact in this case, this probably was a case where they should have been a little careful because that's what it said. However, the issues in this case were, number one, does the Washington made-whole doctrine require the carrier to fully reimburse the deductible before it can make a subrogation recovery? And in the absence of comparative fault, does the Administrative Code require a carrier to reimburse the full deductible? And lastly, does State Farm's policy language that I just read require full deductible reimbursement prior to any subro recovery? Well, guess what? This sounds like a deductible reimbursement case, right? Well, the Washington Supreme Court, and I've described them earlier, took this as an opportunity to construct a major expansion of the made-whole doctrine. And because this case wasn't about a major expansion of the made-whole doctrine, the case itself is somewhat confusing. Eric will talk about this later with the best practices. Because it's a confusing case, it doesn't provide us with all the answers. We'll give you some recommendations that we think are safe, but unfortunately, until another court comes down and clarifies some of these things, there are some questions that still remain. So the holding in Daniels was a major expansion of the made-whole doctrine. It was court-crafted, it's judicial legislation. It expanded the made-whole doctrine unambiguously to deductible reimbursement and more broadly to property damage recoveries generally. It should never have been applied there because that's not what the case was about. Prior to this, it was doubtful that the made-whole doctrine applied at all to auto, property, collision subrogation in Washington. But now, whether in a reimbursement action or a direct subrogation action, a carrier subrogating under Washington law, and remember, you could have complex of laws, a couple different states involved, but subrogating under Washington law, you are bluntly precluded from any subrogation recovery unless and until the insured's damages, including arguably, and Eric will talk about this, the insured's unliquidated bodily damage or bodily injury damages, until those are fully compensated. So this applies the made-whole doctrine to all lines of insurance, auto, property, collision, homeowner, commercial. It isn't limited. It isn't specifically included, but it isn't limited. And this is true despite any contrary language in the insurance policy. So the Supreme Court clearly stated that its interpretation of the policy language I read above is consistent as it must be with the made-whole doctrine and the basic principles of subrogation. So that is the Daniels case, and we'll get into some more details. Secondly, on August 22nd, 2019, the same usual suspects decided the case of Group Health Cooperative versus COON. This case represents a major expansion of made whole into the health insurance arena under state law. We'll not get into whether or not this is preempted by ERISA and things of that nature, but this is now a major expansion of the made whole doctrine with regard to health insurance, and Eric will talk about how it may bleed over, both Daniels and COON, into other lines of insurance. All right, in this case, COON, who was a commercial landscaper who lived in Washington, hurt his knee while playing tug of war. It wasn't even work-related or anything. He just hurt his knee, had surgery, and he acquired a rare infection called an SP infection. This resulted in the amputation of his leg. His lawyer had a very difficult time proving the cause of the infection, as is the case in most infection cases, and the Everett Clinic, where he was treated, believed that he was the carrier of the infection before he even came in, because the SP fungus is very rare and is found in soil and polluted waters, and he was a landscaper. So it was a very difficult case. Group Health Cooperative paid $322,000. The policy gave them subrogation rights. COON mediated the third-party case, argued for $10 million in damages, and because of the difficult case that it was, he settled for $2.3 million. Group Health sought reimbursement, let's say pro rata share, and COON's attorneys advised Group Health that they would hold the lien and requested that they waive it. Group Health filed suit in state court in Washington. They wanted to seek a determination of their rights for the $372,000, and eventually it got all the way to the Supreme Court, and they cited to the questionable decision of Daniels just 3 months earlier, a major expansion of the made whole doctrine, and they decided that Group Health subro rights are limited, quote, to the excess of the amount required to fully compensate the injured person for the loss sustained, including general damages. They also said that Group Health wrongly assumed that an insured may contract for reimbursement without regard to its subrogation rights, which was the law previously. And the fact that the COON's case involved a health insurance policy rather than a liability or casualty policy did not support a different outcome. So this is, again, a sloppy example of judicial legislation from the bench in which they attempted to expand made whole throughout the state and left a lot of wreckage in their wake. This case affected the TRUONG versus ALLSTATE case from 2009, which held that when an insured made a settlement with a third-party tortfeasor for an amount less than liability limits, the settlement was evidence that the insured was fully compensated. And under the COON case, they say a presumption existed, rather. And under COON, they're saying there is no judicial presumption created. The carrier bears the burden of proof of proving full compensation, and this is now a fact issue. So those are the two cases that have created the chaos that we're going to try and sift through. Now, again, we're going to do just a quick recap of, very quick, of subrogation in Washington. I'll cover auto property, and then I'll turn the presentation over to Eric, and he'll talk about PIP and MedPay. We're just going to gloss over this because we want to get to the heart of the webinar, which is these two cases and how it affects us. So auto property subrogation is allowed. We know that the Mies case out of 2005, it makes a distinction between direct subrogation and reimbursement. Property valuation, of course, is lesser of reasonable value of repairs or the difference in fair market value before or after. We can recover loss of use. All these rights still exist. Loss of use is proven by lost profits, cost of running a substitute vehicle, the rental value of someone's own vehicle, and interest. Okay, this is a great state for auto property subrogation, but all of a sudden now we've got the anchor of made whole, which appears to be hamstringing us with even with regard to auto property subrogation. So Eric, why don't you take over and go through a quick recap of PIP and MedPay subro.
Sure, Gary. prior to Daniels, a big case, there were really two major cases that governed Washington subrogation. The first being Thuringer, which basically introduced the made-whole doctrine in Washington generally. And then the other one was this Mahler versus Sukes case, which for the first time really addressed issues of PIP reimbursement. And it was squarely related to that, what you do with respect to a PIP lien when there is a PI settlement, whether there's an independent avenue of direct reimbursement available to the carrier or not. The court in Mahler ruled clearly that there was not, that really every action had to go through a personal injury lawyer, and there was in effect a common fund, that reimbursement was available. They did acknowledge that equitable and contractual subrogation remedies are available in Washington. But again, there was no direct reimbursement option available in the context of PIP reimbursement. That raised a number of questions that then got sorted out by the courts later. Woodley extended those principles to the UIM setting, essentially saying that even though you're dealing with a UIM action, the common fund principles still apply, and that an attorney can still collect its fees even out of the UIM action. Then later from there, next slide here, we get into Woodley a little bit more. Ham also then explains how an insurer must still pay pro rata legal expenses that an insured incurs, even in arbitrating UIM claims. So this is all just reinforcing the common fund principles, but still limiting their application of these ideas to the reimbursement idea, basically limiting it to the context of PIP and MedPay. They expand on that further then in the case of Sherry, which later on then did also say that there can be no allocation or recognition of any kind of comparative fault idea or anything like that when you're talking about the made whole principles. Thuringer was the guiding principle, again, on the made whole doctrine, and this took place before Mahler. That case was notable primarily for, again, introducing this idea way back in 1978. There was policy language there also suggesting that that there were, that there might be some contrary interpretations of how recoveries were going to be distributed, but it was ruled that the made whole doctrine was, in fact, the public policy of Washington. And given that, that would overrule any contrary policy language or anything of that nature. And that's certainly how it got interpreted later by the courts. So you had Thuringer introducing the made whole doctrine. That applied clearly together with Mahler in the PIP context. So you had the made whole rules and you had these common fund rules, which then introduced a whole lot of kind of game playing in with respect to the PIP reimbursement context, because you had personal injury attorneys basically running the show on any kind of PIP, MedPay reimbursement action. They would settle it for whatever they wanted to settle it for, essentially whatever they felt was a good settlement, turn around back to the carrier and say, well, we're not going to reimburse you because our client wasn't made whole. And this was so even when the settlements were for less than the policy limits. So that raised a number of questions and just seemed kind of on its face to be an inequitable result. Because you would always have the situation where an insured's attorney settled the case for significantly under the policy limits. Then they would turn back to you and say, well, hold on, the settlement didn't fully compensate my client, wasn't made whole, raising the obvious question, well, why did you settle the case for what you did if it didn't make your client whole? That really undermines your role really as the insurer's advocate. and that creates some cognitive dissonance, which got addressed later by some of the subsequent opinions in the court. Again, now in the next slide, slide 11, where you're talking about Sherry, that's the case where the court reiterates that full compensation means actual losses sustained, regardless of comparative fault. And again, the courts make an effort, as they did in Sherry, saying we find nothing in the language of the policy to indicate that the parties agreed that a different principle would apply to this contract. But even if it did, it would be unfair because it's inconsistent with our overriding public policy in Washington supporting application of the made whole doctrine. So this is something that you see over and over again in Washington, where there's arguments presented about contrary policy language, or people go in and try to interpret policy language to honor the basic ideas of freedom of contract between an insured and a carrier. And then the court basically says anything ambiguous or inconsistent with the made whole rules will still be interpreted as if they incorporated the made whole doctrine, because that is the public policy in Washington. But again, all of this was being applied generally in the context of PIP and MedPay reimbursement. There was a clear distinction here between PIP actions, MedPay actions, and property damage actions. The Mias case that Gary mentioned earlier was pivotal in that regard. That came down basically applying a distinction based on the fact that with PIP and MedPay, you're talking about reimbursement from what amounts to a lump sum action consistent with common fund principles, with an insured's attorney bringing the entirety of the action, whereas with property damage, there was still a direct avenue of reimbursement. A carrier could file its own claim for property damage that could be parallel with an insured's claim for out-of-pocket damages, and certainly where there's not a limits issue and there's no question of prejudicing each other's claims, that would be the practice, and that was consistently allowed, and there was no question of any kind of common fund. With respect to property damage subrogation, there was really no direct introduction of any kind of made whole principles, and that was how the law was. Here in these following 3 slides, we're getting into some examples of generally how the made whole doctrine is applied. What you get here in this first slide, this is a pretty straightforward example. PIP pays $10K, health insurance pays $5K, the liability carrier pays its $25K policy limits. Then you have an arbitration, a UIM arbitration, determining that the total damages are $40,000. UIM pays $15,000. Then in this scenario, the total recovery from all sources is $55,000. With total damages being $40,000, $15,000 then is subject to potential reimbursement claims. The way this would be handled with an under Mahler and those rules and applying Theringer there would be that $15,000 then is still subject to reimbursement. So both PIP and probably the health insurance carrier would get recovery minus pro rata fees and costs per the common fund rules. The next example, PIP subrogation example 2. Here you get PIP paying $10K, health insurance paying $5,000, liability paying its $25K policy limits. UIM arbitration determines here that total damages are $75,000, pays out $25,000. In this scenario, with the total recovery from all sources being $65,000, but total damages are $75,000 per the UIM arbitration. So what you have here is the insured not being made whole by the settlement, so nobody gets anything. But what's important here in this example is you're having a judicial decision. The UIM arbitration is determining what the damages are. So this is very different from a personal injury lawyer just telling you what they think the damages are and saying that their insured wasn't made whole as a result. And you also have limits being paid here. So this is a very obvious scenario under the PIP principles where there's just no recovery to be made based on subrogation. Then here in this final example, PIP pays $10K, health insurance pays $5K, the liability limits are the 25K limits. Here, the arbitration determines that total damages are $60,000. UIM pays $25,000. In this scenario, with the total recovery from all sources being $65,000, total damages being determined to be $60,000, there's $5,000 extra. The insured was made whole at the $60K, so that $5,000 is then subject to PIP reimbursement minus the pro rata fees and costs per the common fund rules. So there's the made whole doctrine as applied as it was for years and years, just squarely to the medical context, the PIP and MedPay context. This raised a number of questions that tend generally to get raised when there's a made whole application. Who determines the value of the third-party case? What if an insured settles a BI case for less than the policy limits? That gives rise to the sort of presumptions that we described. Are the insured's attorney's fees figured into the recovery here? No. That part at least is clear. That's where Washington courts have kind of come short. Attorney's fees are not included into the recovery. That comes out secondarily under the common fund principles. If the insured is made whole but only by a little, it's still technically made whole. So that's that. What if there are more than one subrogated party? Then you're probably dealing with a pro rata scenario to the extent that the insured was made whole when you're talking about that overage. Burden of proof issues. This is a big deal that we're going to talk about a little further with respect to TRUONG and COON and the way that that's been modified. Again, common fund doctrine does apply to PIP. It does not apply, even under Daniels, it does not apply to what's developed here with the property damage, subrogation, and the extension of made whole to property damage, and I'm going to get into that too. The only times when the court has ever found that Theringer and made whole does not apply, up till now, property damage was exempt. That's changed. Now, really, it only does not apply when you don't, in fact, have a third party and when you don't have a subrogation, which is to say almost never. Comparative fault, the Sherry case came down and stands for the proposition on PIP subro that you don't factor in comparative when deciding whether the insured was made whole. So even if the insured was 90% responsible for its loss, it still gets to be made whole up to 100% of its damages before an insured can recover under the PIP, MedPay, and Mahler application. So in the past, as far as fighting made whole, some arguments that could be made, you could make these distinctions that I've described, that made whole only applied when there was a reimbursement type claim as opposed to a direct reimbursement, that it was limited to MedPay and PIP. And really, the Washington bar basically honored that. I mean, you would have lawyers making all kinds of crazy arguments with respect to the made whole rule in PIP, but everybody really recognized that property damage was separate. As far as fighting the made whole rule, again, TRUONG has always been very useful to raise with respect to PIP disputes, made whole PIP disputes, just when the insured does settle for less than the policy limits. It was clear from TRUONG that the fact that they settled for less than the policy limits was evidence that they were made whole. That got interpreted actually that there was a presumption, so it would then be up to the insured's attorney to prove that even though they settled for less than the policy limits, that did not render their insured whole, which just as a matter of practice, day to day, meant it was a good kind of guiding principle, because then you could raise that and then you could generally get a recovery when there was an insured for less than the policy limits, or maybe negotiate that recovery. And you could use TRUONG to push back against the personal injury lawyers who would be saying that even though they settled for less than the policy limits, their insured wasn't made whole. And there's also a nice ethics rule in Washington stating that when there's a dispute as to something like this, it's up to the personal injury lawyer to maintain those funds in trust, and that any resolution of the dispute was on them, meaning they had to introduce something or file a motion. So you could send a letter saying, hey, there's a settlement for less than the policy limits. This presumes that your client was made whole, and unless you pay us our reimbursement, we demand that you maintain that money in trust, and it's up to you to bring some sort of action to resolve it. It's not up to us. And that was usually very forceful in compelling personal injury attorneys then to kind of play ball and issue reimbursement. So that brings us to the next slide, which really zeroes in on that TRUONG versus ALLSTATE holding. This has been modified now, as Gary indicated, in this new opinion that's come down, this Group Health Cooperative versus COON, which now does state that very clearly there is no presumption that when an insured settles for less than policy limits, it's not a presumption that they were made whole, meaning that it's not then up to the insured to prove otherwise. Instead, it's just, quote, some evidence that they were made whole. And legally what that means is that it's a question of fact for juries, that you could introduce that and say, well, here's some evidence that they were made whole. They introduce some evidence that they weren't, and then it becomes a jury call with the carrier still having the burden of proof to make the necessary showing. I mean, as we all know, I think those who do this kind of thing day to day, these very rarely become jury questions. You're dealing with relatively small amounts of money that don't really warrant a lot of litigation. But what this does now is it provides some more leverage back to the personal injury attorneys to come back at you and say, TRUONG does not provide a presumption. We are insistent that they're not made whole, and it gives them probably some more negotiating leverage. And this is, I think, a good time to mention it, kind of what Gary was alluding to earlier, where you have here a bunch of judges coming in and issuing an opinion that really alters the landscape of subrogation this significantly. One problem with this kind of ruling being issued from the bench as opposed to through a legislative process is when you have statutes and when you have a legislative process, there's a number of hearings and you get testimony from adjusters, people like you, claims reps, people who do this day to day, who talk about what this actually means in a real life way and how important it is to have an uncomplicated process to handle these types of claims and administer subro. And there are a number of hearings. Everybody has a voice. The legislature is fully informed, and there's a very deliberative process before they come down and issue statutes which provide a very, very detailed framework to essentially address everybody's concerns in a more even-handed, deliberative way. The problem here is that you have judges issuing these rulings in Washington without any real hands-on experience actually administering these claims. They're unfamiliar with the day-to-day of this. So they could reach a holding then in COON, basically presuming that somehow these made whole disputes are actually going to be heard via summary judgment processes before the courts, which just isn't the reality and leaves a lot of questions day to day for claims examiners who need to be actually addressing this in a real world way. So that's an issue that you find in Washington, where almost the entire body of subrogation law has come down from judges, as opposed to legislative processes like you find in Oregon and many other states, where it's a matter for the legislature, who's really more properly equipped to really examine the implications of these decisions. Which brings me to the Group Health Cooperative versus COON case. As Gary mentioned, this case unambiguously extends the made whole doctrine now to the context of health insurer reimbursement. Daniels and COON were issued together hand in hand by a court who seemed really bent on having an agenda to really expand the made whole doctrine as far as they possibly could now in Washington. What COON does is it unambiguously extends the made whole principles to healthcare reimbursement, and it embraces this language from Daniels that is about as wide-ranging as could be. The language from Daniels is, whether in the context of a reimbursement request, offset, or direct subrogation action, a fault-free insured must be made whole for their entire loss before an insurer may offset or recover its own payments. Stated another way, the proceeds of any recovery from a third-party tortfeasor, whether in a subrogation action or otherwise, must be allocated in such a way as to first make the insured whole. The key provisions here are they must be made whole for their entire loss, and again, before an insured recovers. And you can imagine kind of what that means day to day as far as actually trying to process these subrogation claims. So there we have COON extending the doctrine to health insurance, whereas before they admit that there was some question based on prior precedent whether that was so. Questions arise in the health insurance reimbursement context due to the fact that these are contracts. It's not like you're applying a body of insurance law necessarily. So there would be a lot of deference to what would be contracted among parties with respect to health care liens. That's all changed now because Washington is saying we have this made whole doctrine, which is a matter of public policy, which is basically going to supplant everything else that anybody ever wants to do in the state. This is what we're going to push down everybody's throats in basically every instance of subrogation. So then moving to Daniels, the big one, this is where they then extend the made whole doctrine to all of property damage claims too. Before, as Gary and I stated, that Mia's case provided a really nice distinction which separated property damage from all of the made whole rules and doctrines that had been being expounded under Mahler and litigated in that realm. And that was very operative for subrogation, and we all got used to it. Me as a lawyer handling a lot of cases there, any reps involved with fielding those kind of cases day to day. It was a workable system. There were a lot of these issues and problems that arose with personal injury attorneys dealing with PIP reimbursement and Mahler, but we all kind of got accustomed to that, and then there was this nice distinction with property damage where we didn't have to worry about a lot of those things. And frankly, not a lot of problems would arise, especially where you weren't dealing with the limits issue. But also, as any Washington practitioner knows, Washington is very aggressive with respect to bad faith litigation against insurers. And there's also the Consumer Protection Act, which supplies a number of additional remedies to insureds to pursue insurers. So insurers are almost always very much on the defensive in Washington anyway. And the Daniels case now is going to create a whole new realm of questions and open up a whole new series of avenues for personal injury attorneys to raise issues and challenge the practices of insurers in Washington. What the Daniels case did, essentially in a nutshell, as Gary stated before, is that it made it very unambiguous that the made whole principles apply to property damage. The language I just quoted you is extremely broad enough even to suggest that perhaps even personal injury damages need to be resolved even before a PD recovery can be made, which would be, as you can imagine, just an administrative nightmare to try to figure out. Just doing a subrogation case. And again, it's restating that the made whole doctrine is the public policy of Washington, which means that it's going to take precedent over any contractual language in an insurance policy. Finally, with respect to deductibles itself, the court, this was one interesting aspect of the Daniels opinion. There's this one question about whether there can be an allowance for comparative fault with respect to deductible reimbursement. The court does appear to open the door to an exception to allow deductibles to be refunded pro rata. What they essentially did in this case is they punted on that particular question because it wasn't really before them. Gary described the facts of Daniels earlier and how what you had was basically a 70% fault finding on one of these three drivers. so only 70% of the deductible is reimbursed. The court, based on its record, could not determine where that other 30% was going to be apportioned. And so even though there's an administrative rule in Washington, which the court actually seems to support, which is that when you have an insured's comparative fault, then the deductible reimbursement could be made consistent with that, and you could have the insured's comparative subtracted from that. The court declined necessarily to affirm that one way or the other because they could not determine, in this case, whether that other 30% was based on fault of the insured or based on fault of that third motorist. So this is open. It's an open question. And we're going to talk about what you really do with this being an open question when we get into the best practices. And this is something that differs from the application of made whole and PIP reimbursement, where the Sherry case clearly states that the insured must be made whole irrespective of any comparative. Here we have Daniel saying maybe in property damage. At least with deductibles, that's different.
Yeah, let me jump in. Let me jump in with the deductible, Eric, on this, and I'm going to leave it on the same screen. And this is a point that I want to emphasize. The court does appear to make an exception to allow deductibles to be refunded pro rata, but that's where there is a finding. Okay, judicial finding for sure. Arbitration finding, we can argue that's a finding, and that should allow just a pro rata reimbursement. But and I just want to talk briefly about the deductible reimbursement aspect of this case, the impact of it, and its effect is much more wide-ranging than this. And immediately after this screen, we're going to go to, Eric's going to go through the best practices for auto property subro and for subro in Washington after these cases. But in terms of where we are now, under Daniels v. State Farm, 100% of the deductible must now be fully reimbursed off the top of any Washington subrogation recovery. Send it back to your insured. That's what Daniels says. Averill, the case which held to the contrary, it's overruled. They overruled the Court of Appeals. And as you'll see, I'll discuss this in a moment, there's a little bit of a tug of war going on between the Washington Supreme Court, who I've described earlier, and the Washington Court of Appeals. The only possible exception is if we have, as I say, a judicial determination of fault. Now, Washington is a pure comparative fault state, so fault determination can be applied even if it's less than 50%. So the bottom line rule is you've got to reimburse 100% of the deductible. I would just do it. However, if there's an opportunity for a finding of comparative fault, the case is tried, you have an ARB ruling, then you can feel reasonably safe. I'm not saying the Supreme Court won't come back and say, but for now you can feel reasonably safe of reimbursing a pro rata share based on comparative fault if you have that finding. And well, let me go back, because with regard to the deductible, it's important to understand that some subrogation professionals assume that if a state employs or recognizes the made-whole doctrine, then the insured must be reimbursed for its out-of-pocket deductible 100%, as well as any uninsured losses before the carrier can subrogate. Unfortunately, this oversimplistic view and application of the made-whole doctrine is not the case in most states. It's a rare exception, which Washington now joins the minority. In the majority of states, the obligation of an insurer to reimburse some or all of its insured's deductibles has nothing to do with the made-whole doctrine. In fact, the Court of Appeals in Daniels, a brand new decision that just came out before it was overturned, sort of agreed with that. Decisions from across the country apply the made-whole doctrine, essentially state that where an insurer and an insured simultaneously attempt to recover all of the damages from a tortfeasor who cannot, because of limited liability limits, insolvency, or whatever, pay the full value of everyone's damages, the insured has priority. But that's far different than an insured claiming that it's entitled to 100% of its deductible before an insurer can subrogate on its own. That's not the law in most states. Florida has some great cases. We have some articles on the website about deductible reimbursement. We have a chart on the website about it, which goes into this in great detail. Please read that if this issue is of interest to you. I'm going to throw this in here before we get to the best practices. There's a couple of quick questions that did pop up, and we're going to answer most of these at the end, but this does not apply to work comp. Work comp is a separate body of law. It's governed by statute. Eric and I handle a ton of work comp longshore in both Oregon and Washington, and it has nothing to do with work comp. This applies only to Washington. I guess, Larisse Rollins, you asked, does this apply to Washington only? Because it's a Supreme Court decision. Yes, it's a Washington Supreme Court decision. This law does not apply to Oregon or Idaho or California or anywhere else. It's just Washington law. But keep in mind, if you have a policy in Washington and you have a loss in Oregon, there may be some arguments as to whether or not Washington law should apply. There's a conflict of law issue there, which we won't get into because we don't have the time. But
I'd also add that Washington, for workers' comp, is a monopolistic state. You do occasionally have some workers' comp from independent carriers in Washington, but for the most part, it's monopolistic. But I certainly agree that there's nothing in Washington's case law or anything that would suggest that the made-whole rules would apply there, at least as of yet. So.
Okay, and before I turn this over to Eric for best practices, which is the meat of this seminar and what you've been hoping for, we've got our trivia question, and here it is. A city in Washington State has the distinction of being home to the world's largest building by volume. Name the building and the city. A city in Washington State has the distinction of being home to the world's largest building by volume. Name both the building and the city. And the winner of that, of course, will get a choice of their book. So, Eric, let's talk about the good stuff here.
Okay, so this is basically where we're left after Daniel's, just kind of as a practical matter of what we do with this and how we adjust the claims practices. And this frankly isn't pretty, because it means a lot of new due diligence and a lot of more work for claims handlers. Carriers should continue to pursue auto property subrogation and certainly property subrogation. I mean, the courts are still consistent and clear that there are generally subrogation rights subject to all of these restrictions. So it does remain legal. It does remain worthwhile to continue to pursue these types of claims. As a best practice, especially when you're dealing with a property claim, even on these auto claims, to confirm that there's no out-of-pocket or uninsured losses before settling the subrogation claim. If you're getting any indications that the insured is particularly active or that out-of-pocket losses are being presented, you want to be very sensitive to that throughout the claims handling process. A smart practice would be to issue a letter to the insured advising that subrogation is being pursued really at the outset. I know a number of carriers already issue those letters. Here, what you'd probably want to do is specify in the letter that you're pursuing subrogation and specify the types of damages and what you're going to be pursuing, and ask maybe specifically if they have certain types of claims, what kind of out-of-pocket claims that they might have, and tell them to contact you. And then again, if there's any contact at all, you want to put everything on hold until they resolve these claims. And as you know, that's going to be a lot of times very challenging because a lot of them aren't going to be represented, and really we're supposed to wait for them to recover on their claims before you recover on yours. As a point of fact, it would probably mean some assistance on your end in helping them make their recovery, or else urging them to retain lawyers to assist them in making the recoveries, or else getting some kind of confirmation from them that they're not making any recoveries. Obviously, it'd be best to get that kind of confirmation in writing if you can. If you want to just make notes of a conversation, that would mean something. Just stating that they are confirming that there are no out-of-pocket claims, and then enabling you to then assert your subrogation recovery. when you're dealing with a limits problem, of course, you want to be extra sensitive. And certainly at the time when there are releases being signed, you want to have a checklist and make sure at that time, again, that that you've done due diligence to ensure that there are no out-of-pocket claims. Because if you recover and if you sign a release, arguably under this case law, if the insured pops up later and asserts an out-of-pocket claim, you need to cut them back in based on what you recovered. And because you signed a release, then you could not go back again after the tortfeasor's insured to recover. You could urge the insured to recover from the tortfeasor, and if there are available limits, they probably can, but at the same time, they have a legal right under Daniels to look to you to provide them with reimbursement for those damages.
Eric,
So,
I think a question that's being begged by the presentation too is, okay, is this only auto claims? Does it apply also to homeowner and commercial claims? I mean, my take is that, you know, arguably it does apply. And the problem with this decision and the problem with judicial legislation making law from the bench in the first place is because these judges are not very good at doing this. There's a lot of gray areas. The language of the Daniels opinion is broad enough, in our opinion, and correct me if I'm wrong, Eric, but it's broad enough to infer the conclusion that it applies to these other lines as well. And this same process that you've described, including these best practices, should be applied, and it will be applied a lot more with more difficulty, of course, in a MedPay or PIP setting. Correct?
Yeah. Yeah. Oh, yeah, absolutely. I mean, and certainly with respect to homeowners types of claims and those kinds of larger property damage claims apart from auto, absolutely. You want to put these practices into place before. So you've got to scrutinize releases very carefully. Make sure that there's nothing there that's overstepping the bounds of what should be released and what you're releasing. But in the past where you could just look at a release and be like, okay, it's limited to the property damage claims. All right, there's not a limits problem. If the insured wants to come forward now and bring a claim of its own, there's room for it to do so. So everybody's good in that respect. And there's actually been some holdings to support that approach. Now, that's not so. Now, you can't just kind of rest on that kind of practice. You need to really go above and beyond and get some assurance yourself and reach out to the insured and make sure that there are no out-of-pocket expenses and that there will be no additional claims before actually pursuing your own claim. So,
okay.
I'm sorry.
Go ahead, Eric.
I was just going to say that's what we get from Averill being overruled. You know, the big question that arises, and you alluded to it earlier, having to do with personal injury claims and BI claims, and whether you actually need to hold off on recovering on a property damage claim or even an auto PD claim before awaiting resolution of the PI claim and the BI claim. And we all know who deal with this day to day in Washington, what that would mean and how that would slow everything down. And it's a really good question, whether now you do need to do that and you need to actually take a look at what's going on the personal injury side before resolving the PD claim. This is a complex question right now. The Mias case was very clear in stating that there was a distinction between property damage claims and other types of claims and the personal injury types of claims. The Averill holding, which was expressly overturned by Daniels, made it, again, basically adopted all of that reasoning of the Mias opinion and deciding as it did in Averill and reaffirming this distinction between reimbursement type claims and the kind of direct subrogation claims that you see with property damage. Now, what Daniels did was it very explicitly overturned Averill in the deductible context, but it did not address Mias. It did address some of the reasoning of Mias, but it did not address Mias's specific holding that BI claims and personal injury claims still exist separate from property damage claims. So going forward, based on this state of the law, rather than urge wholesale changes in claims practices that would mean contemplation of personal injury damages and med damages prior to recover of PD reimbursement. I think it's fair to wait for clarification from the court or some additional holding that addresses that specifically. As of now, even with it being a gray area and there being some risk in doing so, I think it's fair to maintain those as separate considerations, that to limit evaluation and contemplation of the made whole doctrine to the auto context when you're just dealing with the PD reimbursement, and just to look at out-of-pocket just in terms of what you described, rental, loss of use, those kinds of things, without necessarily considering what's going on in the personal injury context now. I think that's a fair approach for now. That could very much be subject.
Yeah, that's the problem, and that's the problem with these courts doing this, is because it leaves us with a lot of questions. Essentially, everyone listening, the question, well, what the hell am I supposed to do? The court has suggested that the insured has to be made whole, but hasn't specifically addressed MEAs, hasn't specifically given us direction on how we handle the dichotomy between a BI claim running parallel to but having nothing to do with a property damage loss.
Yeah.
So, that's a problem that we can't specifically answer for you. I wish we could. But, Eric, do you think we're open for some questions now?
Well, I just wanted to hit this one additional point just about the comparative and kind of where we're left with managing comparative on property damage claims, just because, as I alluded earlier, the Daniels case really punts on that issue. So it's leaving that open. So what does this mean day to day now as far as dealing with a property loss where there's clearly comparative? And I mean, yes, deductible reimbursement means something, but you're still factoring comparative when you're deciding about any kind of subro and how you're going to weigh the made whole considerations of the insured. As a best practice with deductible reimbursement, unless you have a judicial determination of some kind of comparative fault, my advice really is just in Washington to refund the entire deductible. I don't think you want to mess around with trying to figure out some comparative assessment. I mean, it's clear to me reading between the lines that the courts are not favoring this practice of adjusters kind of deciding between themselves what the comparative is and then holding that against the insured with respect to their deductible reimbursement. It's not explicit, but I would advise against that in Washington, certainly. And I mean, the question arises, well, what about something that comes out of arbitration forums? There you're on a little bit stronger footing in applying that as far as a comparative assessment. It's still not clear presently how that's going to be enforced. I think you're okay if there's something coming from a court, if there's been some ruling as to a comparative or a liability finding. I think you're okay relying on that and utilizing that in your reimbursement and in your comparative. So that's really the other open-ended there as far as the best practice. Best practice, I would say now in Washington on deductible reimbursement is just to refund the deductibles off the top, at least until further notice. And then if it becomes an issue on these other types of property losses, in the absence of a judicial finding, just to be very circumspect about messing with some kind of made whole consideration based on comparative.
And again, to put this in perspective, this webinar, and we'll get the numbers confirmed, but it looks like it might be the most highly attended webinar we've had. It's for one state. The webinar that we have a 2-hour webinar, which is on the website, where I go through the auto subrogation in all 50 states in overview from 35,000 feet, had over 100 people less. And this just shows how much confusion and chaos these decisions created and how much of a need there is for some clarification. Thank you, Washington Supreme Court. Okay, we've got some questions. In fact, I think we broke another record too in terms of questions. I promise we'll get to all the questions, if not directly. Now we'll spend a few minutes answering some questions and we'll respond to all of them by email. I want to announce the winner of the trivia contest, Steve Wallen with Amica. Congratulations, Steve. You win an all expense paid trip to Oh, wait, it's a book. You win our book, which is still pretty good. And actually, might probably there's some flights that are cheaper. All right, so the trivia answer was it's the city of Everett, Washington, Boeing's final assembly plant, 4.3 million square feet and 472 million cubic feet. It's the world's largest building by volume. Congratulations, Steve. Now for some questions. There's one that came in here from Matt Grumblet, asked, what about a PIP situation where a carrier recovers PIP money prior to the insured pursuing BI case, getting an attorney? There's no limits issue, plenty of money with the tortfeasor, but when the insured attorney settles their claim, is the plaintiff's attorney entitled to come back for 1/3 common fund fees from having settled prior to the attorney's involvement after we settled with the at-fault carrier? And my take on that, Eric, and I certainly welcome your response, but my take is that, they're entitled to a common fund fee for creating a corpus of money that they are responsible for creating. If you settled independent, I think there's a whole lot of impetus there to argue to any court that might award common fund fees that, hey, I got this money. Plaintiff's attorney did not. Eric, what do you think?
Yeah, I would agree. That's something that does come up from time to time in Washington. It seems, based on the way the Madehold Doctrine has been applied in the UIM setting and other settings, the insured's attorney probably has some basis to make that point. The Common Fund Doctrine has really been applied without limitation. I don't know where that specific question has been litigated, and it's really up to the carrier. I agree with you that it could certainly be argued based on who worked to obtain the corpus of the funds, that there is no right to reimbursement. But I know, as a point of fact, that just to avoid controversy, and because it really is arguable both ways, sometimes the carriers will come back and say okay, and even retroactively cut the insurance attorney back. Yeah, but again, Gary, this is just the way that insurance companies are so on the defensive in Washington. I mean, they've been burned again and again and again, and the bad faith litigation is so active there on all fronts, not only with Subro, but in the claims process and everywhere. I mean, personal injury attorneys really just make a living off of finding some avenue to enter some kind of bad faith.
Yeah, well, I think the states that go down that road are going to find that it's not going to help their economy much. I mean, personal injury suits don't drive the economy. But I've got another question here from Rhonda in Salt Lake City. Rhonda asks, if ARB Forms finds 80% fault on the part of the respondent on a $5,000 auto property subrogation claim, and there is a $500 deductible, will I only have to reimburse $400 of the deductible, or all of it, 400 being 80%? So ARB Forms finds 80% fault on the part of a respondent, defendant, in other words, on a auto property case worth $5,000, and there's a $500 deductible. How much do I have to reimburse? All of it, or 400, 80% of it? Rhonda, under Daniels v. State Farm, as we both indicated, deductibles have to now be fully reimbursed off the top. The only exception is the insured's comparative fault, which in prudence should be applied only after a judicial determination of fault. And as Eric said, I think you're on okay ground if you have an ARB finding of 80%. I'd be real happy with defending that case. Nobody can prevent somebody from suing somebody, but I think you're on pretty solid footing there. The Daniels decision says, let me pull it up here. It says, quote, in its amicus brief, this is the court saying this now. The Supreme Court said, in its amicus brief, the Office of the Insurance Commissioner points us to the final cost-benefit analysis issued during the rulemaking process to amend Washington Administrative Code 284-3393 to its current form. This analysis explains that the party who petitioned for the amendment, which was Farmers Insurance, specifically asked that the rule be amended so, quote, insurers may deduct the amount of an insured's comparative fault from reimbursement. So if an insured is responsible for causing a loss, 50%, you get 50% of the deductible back. Otherwise, it's a windfall to them. So I think you're on good footing with that. Here's some other questions. Rob in Fort Lauderdale, Eric, he asks, does Daniels, well, okay, I think we may have answered. Does Daniels relate only to auto subrogation, or does it broaden the main hold doctrine to apply to other forms of subrogation as well? You want to, I think you,
yeah, I mean, I think that. Yeah, I mean, it really does, certainly with everything we discussed. There was that point about workers' comp subrogation, which, again, as a point of fact, really is never an issue just with Washington being monopolistic and almost everything being run out of the state governmental entities. But there are those few instances where it does arise, but it's statutory, and it's statutory with respect to the same statutes that enable the state agencies to recover. So I would doubt, I mean, I guess workers' comp might still be one exception, but certainly with respect to all other kinds of subrogation in the state, I think that the Washington State Supreme Court really, through these opinions, is going above and beyond to try to make it abundantly clear to everybody that they want to apply the made whole doctrine everywhere that they can. And they feel really good about that. They're very high on the made whole doctrine and its policy implications and the way that it provides all this preference to the insured's interest, and they want to make it clear to everybody that this is the law of the land in Washington.
All right. Lorraine in New York State. Lorraine, that's my mom's name, by the way. Lorraine in New York State asks, what do we do under Daniels when there are insufficient liability limits to cover multiple PD subro claims as well as an insured's out-of-pocket claim? And the out-of-pocket claim could be loss of use, rental, could be diminution in value claims, which are, you know, really on the uptick. Eric, what are your thoughts?
Well, I mean, there you're dealing with the made whole principle in sort of its most direct application. I mean, basically the insured gets paid first. So everybody steps aside while the insured gets reimbursed. So all of its out-of-pocket claims, everything that has not been covered in its policy, they get first. And, you know, this raises another question, which is, because these issues aren't really litigated and everybody knows that the insurance attorney basically throws everything out in the kitchen sink into trying to measure what the insured's loss is where does the pushback come from and where does the scrutiny come from? I mean, in a situation like that, if the insured is throwing out all kinds of damages, goes on, you know, Kelly's Blue Book or something to measure what the diminution is or the replacement value, and maybe they're using measures even on Kelly's Blue Book that favor them that aren't realistic. Where's the pushback for somebody just to come in and say, this isn't reasonable, and say, well, you know, you need a different measure of damages? And the way the courts are, all the leverage here is with the insured to just continue to push for their claims the way they interpret their claims to be and demand that they're made whole, really, unless a carrier is really willing to push it and take them to court and make this an issue for a finder of fact. And then, as we all know, there's a lot of reluctance, obviously, to litigate actions against your own insured as a carrier, especially in a state of Washington where everybody's so sensitive to preferring the interests of the insured and all of the bad faith implications of everything that happens. So it creates a real conundrum for carriers. I mean, I think when you're dealing with a scenario where it really is egregious and the claims that are being made by the insured really are outrageous, I would encourage somebody to just make this a declaratory action for the courts and to not hesitate really to get these things before the courts anyway, because you're still able to bring about reasonable pushback. But all of that said, the insured is preference. In the scenario that was described in this hypothetical, they get paid back first once they're fully compensated. If there's some money remaining under the liability limits, then it would probably be a pro rata distribution among the various subrogating entities trying to recover.
Yeah. Okay. Another question. This is Connie in Baltimore asks, what happens when, as directed in your best practices, we try to obtain the written confirmation that all out-of-pocket claims are satisfied before settling our subrogation, but the insured is unavailable or won't respond?
That's a really good question, and that happens all the time, I'm sure. The thing to do there, really, all you can really do is just document all of your efforts to contact the insured. What you want to do in your letter to the insured is give them a time limitation. Say, unless we hear from you within 60 days or so, we're going to presume that you've been made whole and that you have no out-of-pocket interest. That will give you some measure of protection. Then if they materialize or come back down the line and say, hold on, I'm here and I had all of these claims, it gives you a pretty solid footing to say we really went above and beyond and acting reasonably to ascertain that you were made whole. The courts haven't looked at that. There's no case law on that type of scenario. But I think you'd be on pretty strong ground there. If you go through all those measures of due diligence and do everything you could to contact the insured, if you try to find out if they have any new addresses, if you've sought to locate them where they might be and sent that letter offering a time limit and you're just not getting any kind of response, I think you're okay.
Okay. Mark Gluodenis, I hope I got that right, asked, when you say out-of-pocket losses on a PD claim, are we talking about including their med/casualty losses as well? Mark, no, I think what we're talking about out-of-pocket on the property losses is rental, loss of use, diminution in value, those sorts of things. Deductible, of course, we've discussed, which is sort of a subset. As Eric has alluded to, the Mia's case wasn't really addressed by this sloppy decision. So, you know, we could argue that there's still that dichotomy between property and medical. You agree, Eric?
I think it's still arguable right now. I think with Mia's not being directly addressed by this opinion, they do address some indirectly some of the reasoning of Mia's, but they do directly overturn Averill, which was based on Mia's, but they don't really get into this specifically. They don't really attack the distinction between BI type of cases and personal injury type cases and these property damage cases with direct reimbursement, to the extent where I would expect the court to uphold somebody trying to leverage a BI issue on a PD issue. I think it's fair, given the administrative burden that would be placed on carriers to try to accommodate something like that. I think it's fair at this point, without any further clarification, to just continue to treat those separately.
Okay. Boy, there is a ton of questions. These are great questions, by the way. Kim Davis asks, I assume that this doesn't apply to self-funded ERISA, FEHB, or Medicare plans since they aren't ruled by state law. You know, actually three separate questions. All three of those have three different bodies of federal statutes. You know, in the case of ERISA in particular, the fact is that all state law is preempted insofar as it relates to employee benefit plans under 29 U.S.C. 1144. But again, the savings clause, 1144B, says that law is saved from preemption if it regulates insurance. You know, there's been some crazy decisions coming down again, and we're talking about the same dynamic at play here. Some crazy decisions that saying, well, made whole rules have to do with regulating insurance, therefore they're not preempted. Kim, answer your question is, I don't think there's a specific ruling with regard to this because it just came out, but I think you're safe to say that, yeah, in a ERISA plan that has language countermanding made whole. Okay, that's important. Without that language, you've got nothing. But if you have a self-funded ERISA plan with that language, it would preempt this goofy decision. Bonnie Ann Corbett Walker, does this apply to out-of-pocket rental paid because the auto policy does not have rental coverage? Yeah, I think that would be one of the, in the property damage context, Bonnie Ann, that would be one of the elements of uninsured losses that you'd have to look at. In other words, that would make the insured not whole in the property context. You agree with that, Eric?
I do agree with that. Yeah, that's right. That would be one of the species of out-of-pocket losses where they would need to be made whole before there's recovery. So that's part of the due diligence, is to ascertain whether that might be out there.
Okay. I'm going to run through some of these. Chad Clark. Chad asks, if an injured party elects not to pursue a BI liability claim, does this preclude the PIP carrier from recovering since the injured has not been made whole? In essence, shifting the burden of liability to the PIP carrier. Great question. It kind of smacks a little bit on the question that was asked by Matt Grumblatt earlier. Eric, you want to
Yeah, it's a
tackle that
really
one?
good question. It's a good question, and that's something that's come up for years, ever since the Mahler opinion was issued, and this relates squarely to the PIP reimbursement matter. There's a footnote in Mahler that does allow that, and this happens not infrequently, where a carrier is just kind of sitting on a PIP reimbursement claim, and they're waiting for word from a personal injury attorney coming in to represent the insured, but that's not happening. They still want to assert their claim, and they're coming up against the statute. If it's possible to file that in our forms and just await the tolling of the statute, I'd certainly encourage a carrier to do that. They're allowed to do that expressly under Mahler. If not, get something filed in litigation, wait for the statute to toll. Those are typically paid and recoverable. With the statute having tolled, I think they're, at least arguably, the insured no longer has its claim, so there's no made whole impairment on the carrier just bringing its claim. I mean, to be on the safe side, sometimes as an attorney retained in that scenario, we might also bring the insured in and just handle it as a personal injury matter, and then also ensure then that the carrier's lien is protected that way. But there are certainly remedies available, and that's something you do want to keep your eye on and make sure that you get that compensated.
Okay. Army Turner, hi Army, how are you doing? Army asks, the entire loss where no coverage was purchased for UIM, or any excess exposures for property items on, say, a stated value policy. Entire loss where no coverage was purchased for UIM, or any excess exposures for property items on, say, a stated value policy. So we're talking about something other than auto here, I presume. Eric, do you have any thoughts on that?
Yeah, that's what that sounds like to me. I mean, that kind of relates to this distinction between PD and VI damages.
Yeah, here's what I'll do. Army, I'll shoot Army an email. Okay. Army, I'll shoot you an email. We'll clarify that, because we've got a bunch of questions to ask. How about one or two more? Kim Davis asks, are you saying refund deductible when there is comparative fault for health insurance carriers? We've been talking in the context of auto here. Now, this raises a kind of a new issue in the context of a health insurance plan that has paid benefits, but the beneficiary or insured has eaten a deductible.
Yeah.
And you want to go subrogate. Thoughts on that one?
That's a really good question, and it wasn't addressed in Daniels. And because Daniels leaves open the question of comparative, but again, the reason why Daniels leaves open that question is because there's that Washington administrative reg.
Exactly, which deals with auto.
Right.
Yeah. Okay.
Exactly. So
go ahead.
So I was going to say, if you're dealing with healthcare, you really have to look at the rest of the contractual, what governs contractually there. And as you said, to try to determine whether it's somehow preempted. I mean, under the COON opinion, they seem to be suggesting that the made whole principle applies in an unabridged way now to healthcare.
All right, let's take one more. Brian Scott asks, this is a good one, Eric. Yeah. Any comments on the fact ignored by the Supreme Court but cited by the Court of Appeals that after reimbursing the insured 70% of the deductible, State Farm pursued and recovered the remaining 30% from Geico in intercompany ARB and then paid the insured the remainder of her deductible?
That's great. Yeah, and which is completely ironic and funny. And very convenient, actually, for the Supreme Court not to make reference to that.
Yeah, and they're obviously with purpose.
Right, exactly. Yeah, because that would have changed the entire analysis.
Yeah, and I think, Brian, the answer is, yeah, I mean, it's nice. You don't know that, hindsight being 20/20, you don't know that you're going to get that 30%. So the Supreme Court is saying, you make the insured whole. If you go get your 30% after that, that's fine. But the insured will have already received 100% of their deductible back. Yeah, it's
right. Absolutely.
Comments on the fact? Well, you know my comments on that. It's ridiculous. So, okay, we've got a number of other emails and questions here that there's still some coming in. I don't know whether that's good as a reflection of, hey, we hit a topic that is obviously needs some in-depth analysis, or we just didn't do a good job with the webinar. Eric, I want to thank you so much. for participating. Eric and I will both be addressing these questions, and feel free to email us back and reply until you get, you know, the answer that that you need, so you understand fully everything. If you have questions, our website is on here. Eric's website is on here. Of course, we have a lot of those references. I would direct you to, because we're talking a lot about deductible, because one of these cases was specifically about a deductible, even though they expanded it to more than that. There is a deductible reimbursement chart that we have on our website, which shows the law in all 50 states, and it has been updated for Washington and for this crazy opinion. So, Eric, thank you again. I appreciate your
Thank you, Gary. It's really been a pleasure. I always enjoy doing anything like this with you. It's awesome.
All right. Thank you all for attending. Today's 9/11. Never forget. We'll try and answer all the questions as soon as we can. Thank you again. Bye-bye.